So let's get started first with talking about that preparing our witness part, okay? I want to make sure that I prepare my witness, and I'm talking about that cross-examination part. I have to explain it to a witness. I even do this with my expert witnesses that so-called do this for a living. I gotta get them oriented with the process of witness examination. I've talked before in other lectures about how this trial is a disjointed process of information. It's a lot easier to stand up and deliver a speech. Here's topic A, here's topic B, here's topic C. They all fold in sequentially, and then we get to the conclusion that I want you to find. Unfortunately, trial and the process of trial doesn't come out like that. It comes out all jacked up. It comes out witness by witness, and then even worse, within each witness's testimony, direct, my side, cross, your side, redirect, my side again. Imagine being people that are unfamiliar with the process, like jurors, trying to receive information in this disjointed, jacked up way. Well, as much as it's important for you to clarify that in jury addresses, like opening statement and closing argument, right, I have to make sure that my witnesses, the ones I'm preparing, know the process of trial and know how it comes out. I do something like this, where I actually tell them, first is a direct examination. That's our dance right now. That's something you should have very little worry about. Why? We're going to go over every drop of it. You're going to know the questions. You're going to know the areas of inquiry. You're going to know, we're going to go over your answers. You're going to tell me back. I'm going to tell you some of the problems, how we can think about testifying. I'm going to go through that ad nauseum. We are going to cover our script and our play together. We're going to put it on. You're going to testify. You're going to talk to the jury. We are going to do that. And if you think about it, what we handle in direct examination when I present my witness is really, it's determined by the rules of evidence, and they can object to certain questions. But the overall scope, the overall the topics that I can cover in direct examination is really dictated by two things. And that's relevance. It has to have something that moves the ball forward. And this witness's personal knowledge. Now, of course, personal knowledge is something that's usually for the precipient witness. That's usually for the fact witness, not an expert. But if you think about it, what confines a direct examination is that the facts have to do with something. It has to be relevant. It has to move the ball in some way, shape, or form. And this witness has to have some personal knowledge, but for an expert. And the expert, it actually is more confining because they had to have told us in some type of disclosure before. So they either have to know about it, personal knowledge, or they have to have turned it over in some type of disclosure pre-trial. That's what defines our direct examination. And I tell my witness, we're going to go through every drop of it. I also tell them about the mechanisms that we talk about in other videos, like refreshing recollection. If you forget something, or you drop something, here's the process by which we can get that back because you've said it before. So I give them comfort level in knowing, here's what's coming, and here's how we can get at things even if you should forget. That's direct examination. I then have to explain to them what's coming by way of cross-examination. I like to hold exactly separate sessions about cross-examination. If I'm going to meet with you on Tuesday and Thursday, I want to make sure that Tuesday we're covering the direct and we're doing our script and we're doing our question and answer again. On Thursday, I'm going to show up in a different character. I'm going to show up playing the part of the opposing attorney cross-examining you. I'm going to show you what cross is like. You do a disservice to your witness if you don't show them the difference between a leading question and an open-ended question. You do a disservice if you don't show them the attitude, the shortness of the questions, the confining nature of the questions, essentially the unfair or potentially unfair process that is cross-examination. If the first time that they hear a batch of leading questions launched at them is at trial, you have failed that witness. So one of the things that I want to do is I want to talk to them about cross-examination and why it's different. What defines what goes into cross-examination is very simple. The scope of what you covered in direct. The topics that you covered in direct. If you covered ABC in direct, ABC topics are in bounds and in the box for your cross-examination. And then there's one important matter that is in addition to ABC all the time, and that's credibility. Credibility is always within the scope. If someone came into court, put their hand up in the air, swear to tell the truth, then everything that comes out of their mouth, right, I want to be the truth. Every issue that bears on their credibility, I am able to bring up in cross-examination. So the way I like to say it is what defines what can go on in cross-examination is everything we covered in direct and everything that bears on your credibility. The witness has to know that. Because you will get the witness, and I've gotten this witness before, when you get off the stand, you get out in the hallway, you get to lunch, they come to you and they go, what the hell was that? They started asking me about the time I lied on an application. They started asking me about a prior conviction. They started asking me about who my brother was and what was the relation of that to the case. Guess what? All bears on credibility, all well within bounds. If I didn't prepare you that that stuff was coming, then I failed you as the witness preparing you. Prepare them for direct, prepare them for cross. Then I'm also going to tell them what's coming next. I'm going to tell them about redirect. And essentially the way I want you to think about redirect, it further narrows, it further funnels. If I'm cross-examination of among A, B, C, and D and credibility, right? If they only covered A, they didn't go into anything on credibility, they didn't go into anything on B, C, or D, if they only covered A, that is the only thing available to you in redirect. It's only a narrow subset of what was covered in the examination before. So what I'm going to look at is the scope of what happened on cross-examination. And it's also designed not to repeat, but to repair. Right? I don't get to just get the last word. Oh, redirect? That means I get to say all my good points again, just more recently. No, you don't. You don't get to just say it again because you have the ability to go after. You have to have it where it repairs or it clarifies something that came up in cross-examination. And we'll talk about it a little later, and we'll also do a demonstration today. There's also a recross. And this, the best way I will tell you, is this is a function of the court, most likely. Sometimes courts like recrosses, sometimes courts do not like recrosses, but it's the same thing. It still funnels, it's still within the scope. Most of the time, for redirect, the judge is going to look at you after cross-examination, and they're going to say, counsel, do you have any redirect? There's actually a question. They actually remind you. They actually wake you up in the middle of trial and say, do you have any questions for redirect? And if you do, you go. If not, you say, no, I don't. Witness is dismissed. For a recross, most often, even if a judge is inclined to permit it, they ain't going to be asking. Can this witness be excused is the word that's going to come from the judge. You may have to intercede and say, Your Honor, may I have a question on recross, something that came up in light of the redirect. And that's what it has to be. It's not you repeating what came up in cross, it's you coming up with something in light of what happened. So let's